Thank you for joining us for our session on boilerplate and contracts. This is part of an occasional series on different aspects of boilerplate and contracts. My name is David Lowe. I lead our commercial contracts team, and I'm a non-contentious lawyer, so I focus on drafting and reviewing contracts.
And my name's Sean Adams. I'm a partner in our commercial disputes team, and I see these contracts from very much the other lens and the other side, and see them when they go wrong and when people are falling out and looking at termination or disputes. So hopefully between the two of us, you get something of a balanced view across one of these issues.
And of course, boilerplate is relevant to every contract. And often it becomes really important when there's a dispute, which, that's why you can have the perspective for me drafting a contract and Sean's perspective in what happens when it goes wrong. And in this session today, we're going to focus on the parties. And by that, we mean who are the parties to the contract and how it can be changed through assignment or novation, and also how you can use third parties and agency. So, Sean, let's start with the parties. Now, pretty obvious to me as a drafter of a contract that you've got to be clear who the parties are. So why are we even mentioning this?
Yeah, absolutely. And I'm glad it's clear and it's always in your contracts, David, which is great. But you would be surprised how many times the client comes to us, they've ended up with a dispute with a supplier or a customer, and they send you through the contract, which is 5 years old, and you open it up. And actually, it's not entirely clear who the parties to this agreement were, even at the outset. And that might be as simple as people have only put in a name and they've used a trading name rather than a legal name. It might be that the party that existed 5 years ago when this was entered into has now changed its name 2 or 3 times. There might be all sorts of other complexities that we'll come onto around variations and novations and assignments and that sort of stuff. But actually, when you get to a dispute, when you get to the end, the last thing you want to be having any sort of satellite dispute over is who on earth am I in a contract with here? Because it just adds another layer of complexity, it adds another layer of cost. So I think my top tips from that perspective are, it's really easy when you're going into a contract with somebody to identify who it is you're contracting with. You'll be doing all sorts of other commercial things like diligencing your counterparty and making sure you're going into business with them. So just put a bit more detail in that parties section of your contract to make sure that's beyond doubt forevermore. Using things like company numbers where you're dealing with a corporate, which even if somebody changes their name, you can then track back and find exactly which corporate entity we're talking about. That's really helpful. Things like addresses can also be helpful. Again, they change, but you can tie somebody at a point in time to a place. That helps. Where you've got variations, novations, things like that, make sure you're keeping a nice clear record of those. And that probably applies to all changes, not just to the parties. And where that's getting more complex, I think, you often see a conformed copy of an agreement that sort of sweeps in 2 or 3 years worth of variations. And I know from a drafting perspective, you'll look at some change control and things like that around how that's monitored. But think about it from the perspective, what's hoping you never get there, of if I end up in litigation over this and I have to send Sean my contract in order for him to tell me whether I'm in the right or not, how can I make that as straightforward as possible and stop the exercise of having 3 or 4 rounds back and forth as we try and work out what the contract is and who the parties are?
Yeah, and certainly I think, if you're varying a contract, it's good practice to sort of record, is this the 3rd variation of it? Because that gives you a clue then that there's more variations to ask for. I recently had that myself where it was 5 variations and I was only given 3. So because one of the variations referred to how it was the 5th variation, I knew to ask, hey, there must be two more out there. So constantly doing that and having an eye to what happens if I have to bring together the whole contract is really important.
I completely agree with that. Shall we move on to assignment and novation?
Yeah. So it's very common, isn't it, to have in a contract in the boilerplate clause that says something like this: a party may not assign any of their rights or responsibilities under this agreement. And so there's often a debate about, is that appropriate? Should there be a restriction on assignment? Can there be assignment within a group so that you could move the contract around a group? So you might say parties may not assign it accept that they can assign it freely within their group, or a party may not assign it without the other party's consent, not to be unreasonably withheld or delayed. They would be your common variants. But often what is missed is actually assignment actually has only a limited role, because assignments can only transfer the benefit of a contract. They do not transfer the burden. And the only way in which you can transfer the benefit and the burden is through a novation. And so I'm often asked by people about assignment clauses, when actually what they want to do is transfer the whole contract benefit and burden. And I then point out that the assignment clause isn't going to give them the complete answer, it only gives them part of the answer, because we can only transfer the benefit. Now, what do I mean by the benefit of a contract? Let's imagine I am supplying window cleaning services to Sean. If I assign the contract to a new supplier, I transfer the benefit of my contract with Sean to that supplier. And the benefit is the right to be paid. So I haven't transferred the burden being the obligation to clean Sean's windows. So the assignment, all I've done is transfer the benefit, the right to receive payment, and not the obligation to do the services. Now I can build on that. I can then go to the new supplier. Oh, and can you also go and clean his windows, and therefore create some kind of collateral contract? But now we're getting complicated and messy, when all I wanted to do was transfer the contract. So how do we go about this? So Sean, we've got a slide with some pictures on, haven't we? Here they are.
Okay, so makes it easier to understand, hopefully.
Yeah. So the red line is what happens on an assignment, in that the benefit is being paid. So if I merely assign a contract, all I've done is transfer the right to be paid. And that means, as you can see from this services assignment blue line, the obligation to provide the services sticks with me. But as you can see, we've flagged that if you novate the contract, then you transfer the entirety of the contract, the obligation to perform the services and the right to be paid. Now, how do you do that? Now, the best practice way of doing a novation is to have a three-way agreement between customer, old supplier, and new supplier, which says, hey, the old contract is no more. There's now a new contract on identical terms of the new supplier. And it may then deal with what about handover, what about transfer of liabilities. It might deal with varying the contract. You know, maybe the charges have been changed because there's been a passage of time. So that's all pretty normal novations, and many of you will be familiar with novations. But the problem with a novation is, well, firstly, it's administration. Somebody's got to sit down and write out a novation and work out who's what and write it out. Now, it's only a very short agreement typically, but somebody still has to do it. So that causes administration, that causes delay. But the even more important reason is you need the customer to sign it. So if the customer is a helpful customer, this might be all really straightforward and the customer simply signs it and job done. But often customers hesitate. They'll either go, well, I'm not going to sign something until I've got my lawyer to check it. Time, money, delay. Or worse, the customer goes, I'll agree to it, but only if you cut your prices by 5%. Or I'll agree to it, but only if you reduce the term, or introduce some other variation. And the customer will then use it as leverage, knowing that you want to transfer the contract, and therefore you're going to try and find a way to agree to the customer. So none of this is very attractive. We don't want the customer having control, and nor do we want the time, delay, hassle of the admin. And so what you can do is something called novation by conduct. This is something that you're not taught about at law college, and therefore people don't have an understanding of what novation by conduct is, not to miss it. But basically what the courts say is, if the old supplier has written to the customer and said, I'm transferring the contract to the new supplier, and here's the new supplier's details, and please pay the new supplier to new bank details, and the new supplier will now issue you invoices. And the customer doesn't object, and then the new supplier provides the services, issues the invoices, and the customer pays the new supplier, then eventually the courts will say, well, even though nothing's been written down and there's no formal novation, there is a novation by conduct. It just happens. Now, the problem is it's very difficult to say exactly when has that happened. It definitely hasn't happened on day zero when you just told the customer. But broadly, when you look at the case law, once a couple of months of payments have gone through, a couple of invoices have been paid to the new bank account, the suppliers provided services a couple of months, then almost certainly the court will say novation by conduct has happened. So for routine business sales, for example, where there might be hundreds of contracts that need to be transferred, this is how it's done. This is normal. People don't bother with hundreds of novation agreements. They just do novation by conduct and cross their fingers and hopes the customers don't object. Because the problem is if the customer receives the initial notification and objects, then the customer can stop that novation. But in my experience, the customer very, very rarely objects.
I think the only thing I'd add to that, David, is obviously it brings with it an obligation to be vigilant. So depending on which side of this chain you're on, if you receive one of those notices that someone's sending you hoping you'll ignore it, if you don't want to ignore it, you're going to need to act. You can't just fall into this new pattern. So make sure you're live to that. And also, I think for for business critical contracts, they're probably the ones where you need to think about a more formal approach. I think, for your, as you said, in a routine business sale where you've got hundreds and hundreds of contracts, it's probably not practical. But I suspect in those, by the time you've dug into them, there are a few where you actually want more certainty than that and will need to apply closer scrutiny so that you're not relying on some of the law. The law is there and it will ultimately protect you if you end up in one of these scenarios where that novation by conduct goes through. But you are going to have that slight uncertainty for a period. And similar to the points we were discussing about parties, it depends on whether you can wear the risk of that uncertainty. And that's going to turn on what the contract is, what it's for, how it affects your business, etc. That was all I had on that one. I mean, I think another approach, we've got a slightly different diagram, which blissfully was easier to put together, but another way to deal with this exercise where you have got different parties involved in the ultimate supply is you look at a subcontracting arrangement of some sort. So if we move on to that, so you've got there your supplier-customer relationship, and it's possible to put a subcontractor in behind the supplier. They're two different contracts. Is that something you see when you're putting together these structures, David? Is that more common, less common than assignment novation?
Yeah, definitely. I mean, it's subcontracting is common. Obviously, all businesses are reliant on other businesses to be able to supply their services. So to some degree, every business is involving other parties in order to allow it to fulfill the services. What we mean by subcontracting, though, is, for example, in my window cleaning contract with Sean, the fact that I've rented my van off someone that have bought the paper clips in the office, they're not subcontracts, really. I'm not passing down to somebody the obligation to provide the services or part of the services I'm providing to Sean. But if I had a new supplier, Sean had objected to the novation, go, no, David Lowe, I chose you, I wanted you. Then unless the contract says to the contrary, I am allowed to subcontract freely to somebody else and get them to go along and clean Sean's windows. Now, Sean has to, if he's unhappy with the windows, has to deal with me. His contract is with me. He would sue me ultimately if it got that bad. I have to invoice him, he has to pay me, and then I have to separately deal with the subcontract. So Sean and the subcontractor don't actually have a direct contractual relationship, and I'm stuck in the middle. So that's why it's not ideal if you in reality wanted to use this way of transferring the contract, but it's better than not being able to do it at all. Now, if your contract is silent, then you can freely subcontract. The only exception is if it's a personal contract, and the case law is sort of like personal tailors and butlers and so forth. So in the business world, it's unlikely to be relevant. So if your contract says nothing about subcontracting, then the supplier can subcontract. And that's why it's common in contracts, particularly more substantial contracts, for there to be some kind of control over subcontracting. The customer has chosen the supplier, has carried out due diligence over the supplier, got themselves comfortable the supplier can do it. The customer doesn't want the supplier then to sidestep all that and get somebody else involved, at least not without the customer's involvement. So it's common to say you can't subcontract without the customer's consent, not to be reasonably withheld or delayed, or you can't do any material subcontracting or some other controls over that approach.
No, that makes a lot of sense, particularly as for all sorts of different reasons in the current day and age, people wanting some degree of control over what their supply chain looks like and their ability to understand what's in there, as much as making sure the party they're in a direct contract with is the one that they have the ability to substantively go after if it all goes wrong. So very briefly, I think there are a couple of other options we just wanted to touch on in terms of achieving similar things.
Yeah, I wanted to touch on third parties because we all know that in a good boilerplate of a contract, typically there's a clause about third parties, may even specifically mention Contracts Rights of Third Parties Act. And the reason for that is the Contracts Rights of Third Parties Act 1999 allowed the parties to a contract to allow a third party to enforce and have the benefit of the contract if they're nominated in the contract or otherwise identified or a class of people. So that legislation opened the door to the potential risk that a third party might have rights over a contract. So for a normal standard contract, the parties probably don't want any third parties to have anything to do with it. It's a contract just between A and B, and we don't want party C to have anything to do with it. So that's why it's common to have in the contract a clause saying no third parties have any right, to make absolutely sure there can be no argument that a third party can get involved. And so that's why it's quite an important clause to make sure there is no argument. In fact, quite a lot of the case law is where the contract has been silent and there is a debate about whether a third party has a right or not. So good practice is to have a clause saying there are no third parties have any rights. My big but, though, is I think people just blindly put in a clause saying no third parties can have any rights without thinking about actually might it be useful to grant third party rights, because the legislation was introduced to allow for people to allow third parties to have rights and therefore hopefully cut out some of the admin. And the classic example is in group procurement. If one company in a group is buying goods or services, but it's for the benefit of somebody else in the group, or granting that other member of the group third-party right helps cut out putting in place contracts or putting in place sort of acrobatic contracts that try to sort of be between two parties but be with another party, and which are often is done badly. So I do urge you to think about whether you should use the Third Parties Rights Act for your advantage and grant those rights to third parties. But if you do that, you need to make sure the drafting's right, and you also need to expressly deal with the right to terminate and vary. So if the first time you do it, it's well worth checking that you get the drafting right before you do it.
Yeah, I'm glad you added the note of caution there, David. At least if somebody excludes all the third-party rights, it is relatively clear what they're doing. When they include them but have a very short clause, you can walk into trouble with some of those bits hidden down in the act. So yeah, certainly worth having that wording reviewed if that's the route you're going down. And the last one I wanted to just very briefly touch on is agency, because it's sort of connected to some of these things, albeit doing something different. But the law of agency, far too complex for this very short video, but you quite often see a clause in a contract which says something like, this contract isn't creating an agency relationship, it's not creating a partnership. Two things I wanted to mention. First, if you're going to put that clause in there, make sure it's right and you're not in substance creating an agency relationship, because that can cause untold problems. And the second is just be very careful of agency generally, because what's happening when you have an agency relationship is you've got effectively someone with the power to bind a third party to a contract, but the contract you're creating is between the principal and the third party, with the agent being something of a middleman and acting on behalf of its principal. All sorts of different obligations wrapped up in that, and it can create some real complexities in particularly in a contractual scenario, but just generally, if a dispute happens and you've got agents involved, the whole thing gets a bit messy relatively quickly. So a flag, if you see the word agency in there, it still carries a lot of legal weight. It is doing a particular thing, and just make sure you understand what's happening and you know who you're contracting with and in what capacity.
Yeah, I agree. I mean, agency can be really useful, again, way of cutting through things, much like third parties can be really useful, but it's to be done with care. Particularly if you're going to appoint somebody as an agent, I definitely strongly advise that you make sure the authority of the agent is clear. You may, for example, make it clear that the agent is not allowed to enter into contracts on your behalf to try and reduce the risk of them going off on a frolic of their own.
So I think that's us done for this one. That has been a relatively whistle-stop tour of some quite big topics, I think, there. But thank you for taking the time and listening to us. Our contact details on the screen. So if you've got any questions, please just feel free to reach out and let us know. Also, as you may have seen from the reference at the bottom there to ThinkHouse, this is the sort of topic we quite often cover in our seminars, usually around commercial contracts and updates and various things like that. We'd be delighted to have you along. There'll be a link next to or near this video should you want to sign up if you're not already on the mailing list for those. So we look forward to seeing you at some point in the future.